So a new case challenging a statewide ban on magazines that hold more than 10 rounds is now seeking Supreme Court review. This is one of those cases that a lot of people are overlooking, but this would be huge for all states that have magazine bans. So let's talk about what is happening. Now, real quick before we jump into this video, I want to ask you all for a huge favor. Looking at some of my analytics, about 60% of all my viewers are actually not subscribed to the channel. So if you want to support this content for free, one of the best ways to do that is simply subscribing to the channel. YouTube loves to unsubscribe people, so also double check that. And then I also want to mention that we have a newsletter available that you can sign up for. Links will be down below where you can sign up. And also one of the cool things about that is we're going to be doing a monthly giveaway once we reach 5,000 subscribers on the newsletter. And if you are a member of the newsletter, you will be automatically entered every single month to win that prize. Now, like I mentioned in the intro, in this video, we're going to be talking about a case that is now in front of the Supreme Court, and it's challenging a state's ban on magazines that hold more than 10 rounds. We've seen multiple times now the Supreme Court has had cases in front of them that deal with magazine bans. One of the most recent ones was a case out of Illinois, or a bunch of cases out of Illinois. And after Rahimi, those cases were sent back down. Now, one of the cases that, was still pending in front of the Supreme Court has kind of made it through that whole process, mainly because some petitions and things need to be filed, is a case that is challenging the state of Rhode Island's ban on so-called large capacity magazines, or magazines simply that hold more than 10 rounds. The case we're going to be talking about in this video is the Ocean State Tactical case. And again, this is a case pending in front of the Supreme Court. It's seeking a writ of cert for the Supreme Court to take review of this issue and ultimately strike down a statewide ban on magazines. Now, for those not familiar with this issue, just a couple days before the Supreme Court issued their Bruin decision, and really in response to what was coming in Bruin, the state of Rhode Island enacted House Bill 6614, which was the Large Capacity Feeding Device Ban Act of 2022. So this was a law passed in Rhode Island back in 2022. And as the plaintiffs state in their petition, the act does what the name suggests. It flatly bans all devices that feed ammunition into a semi-automatic firearm, so essentially AR-15s and AKs, if they are capable of holding more than 10 rounds of ammunition. So again, a very blanket and simple ban on magazines that hold more than 10 rounds. They go on to say in their petition that the act does not just make it illegal to manufacture, sell, offer to sell, transfer, or purchase these common arms. It also criminalizes the mere possession and empowers the state to throw citizens in prison for up to 5 years, even if the arms that the state now deems criminal contraband were lawfully acquired long ago. So unlike other states, it seems like the state of Rhode Island not only has a future ban on the purchase and acquisition and sale of magazines that hold more than 10 rounds, but it seems like they don't have a grandfather provision either. You see some states, when they try to ban magazines, they will grandfather in those magazines that people already possess. But here, what the plaintiffs are saying very expressly to the Supreme Court is that the state of Rhode Island took a different approach. They are also criminalizing the possession of these magazines that they already lawfully had in their possession prior to this specific ban. They go on to say that procedurally, the applicants here, the plaintiffs here, sought a preliminary injunction, which the district court denied. So originally when this case was filed in front of a federal district court, they were seeking a preliminary injunction to halt the enforcement of the state law, but that was denied. Now, as many of you are aware now, if you've watched this channel for a long time, preliminary injunctions are just temporary stopgaps. They are used to, in some ways, try to prevent a law like this one from ever going into effect. I know right now there's a lot of discussion about, well, maybe we should just bypass preliminary injunctions altogether and just move cases towards like motions for summary judgment and final merits decisions. But really, when you have situations like this, where a state is putting in place a new law, like a blanket magazine ban, preliminary injunctions are the fastest and easiest ways to try to stop a law from ever going into effect. So it's kind of one of those double-edged sword issues where if you bypass a preliminary injunction, you are almost allowing the law to go into effect. And so if you just automatically just say, no, we're going to bypass preliminary injunctions and just move towards final merits decisions, you are pretty much running that gambit of saying this law is going to go into effect, and the only way we're going to get rid of it is if we ultimately finally win the case outright, which could take years. They then appealed that denial of the preliminary injunction up to the First Circuit Court of Appeals, but the First Circuit Court of Appeals affirmed that decision of the lower court. Now, the First Circuit stated something very interesting, and they came to an interesting analysis when they upheld what the lower court said, essentially protecting this ban on magazines. The First Circuit stated that they started with the applicant's Second Amendment claim, and the First Circuit assumed, without deciding, that ammunition feeding devices capable of holding more than 10 rounds are arms within the scope of the Second Amendment, and therefore proceeded to consider whether or not the HB 6614 is consistent with the nation's history and tradition. So unlike some other courts, the First Circuit here said, yes, we are going to assume that these magazines here are in fact arms within the scope of the Second Amendment. And then they went on to look at the history and tradition, and the history and tradition would have to actually support a blanket outright ban on the purchase, possession of all magazines that hold more than 10 rounds. But then, interestingly, the First Circuit also found that there was no historical tradition of flatly banning arms commonly owned by law-abiding citizens for lawful purposes. And that's really because there are no historical supports for an outright ban. Now, you may say, well, then how did the First Circuit uphold what the district court said? How did they uphold actually denying the preliminary injunction and keeping this ban in place? And that's because the First Circuit then went on to do something completely different. What the First Circuit then moved on to do is they just completely changed the analysis. They went on to say, well, there is a high society issue, a societal phenomenon where these types of magazines are being used in shootings, and that in the public's interest in this kind of nuanced approach of this changing technology and the changing societal concerns would justify outright banning these types of arms. So again, this is something where you kind of are seeing a backdoor approach where they're trying to bring in an old analysis, which is the balancing of interest, trying to uphold a ban based on the public's best interest. This is something that the Supreme Court rejected in Bruin. They got rid of the two-step approach. They got rid of balancing of interest and the tiered-based approach. But here you have the First Circuit trying to backdoor in that analysis into the Bruin, analysis itself, even though Bruin directly rejected that type of public interest and weighing of interests. So because the First Circuit just completely botched the analysis when it came to magazine bans, they did not appropriately apply Bruin or Heller or any of these historical supports or these Supreme Court precedent, the plaintiffs here then filed a writ of cert to the Supreme Court. Now, again, this is an interlocutory case. It's dealing with a preliminary injunction. As we've seen, the Supreme Court does not typically like that. Now, what was interesting, there was an application that went to Justice Jackson, and Justice Jackson did grant that application and extend some time for the filing of the writ of cert here. And really, that's also because there were a bunch of other cases during this term that were pending, like the Rahimi case. And the plaintiffs here said, give us additional time to file our writ of cert, to file our petition, because the language in Rahimi that you guys issued the Supreme Court could impact this specific case. So the Supreme Court also gave them additional time to file their, language here for their specific request for a review of magazine bans. So here what the plaintiffs are asking for was additional time. They got additional time in light of Rahimi. It was extended out, so I believe on August 5th, the additional petitions here are due in this specific case. So August 5th, this is going to be further briefed in front of the Supreme Court. Now, if you were to ask my opinion, I think if they were going to grant a preliminary injunction interlocutory review of a magazine ban case, it probably would have happened in the Illinois cases. They've already shown expressly, the Supreme Court itself has stated that they want final merits decisions. And if they get a final merits case, they will probably grant review to this case and address this issue. I think there's a better chance that one of the cases out of California, maybe like the Duncan magazine ban case, once it's ruled on by the en banc panel in the Ninth Circuit, maybe then at that time, when there's a petition from the Supreme Court, they would grant review to that case. Or if the Fourth Circuit finally moves on the Bianchi rifle and magazine ban case, maybe at that time, since that one was also GVR'd like the Duncan case, they would take review of that. But it's still good that you're seeing someone try to fight back against the state of Rhode Island and their magazine ban. So that's what's currently going on with the state of Rhode Island and their outright ban on magazines. Of course, if the Supreme Court by some miracle granted review to that case, that would be huge. But if anything else changes, if anything else develops, I will let you guys know. Also, if you like this video and you'd like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of two-way news. But as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by our scholars.